Ladies and gentlemen, welcome to the criminal law process. So we are about halfway-ish through Unit 7 on the criminal and civil law processes, and we have already talked a little bit about criminal law. So types of crime, intensity of crime, and we haven't really been able to dive into the actual process from arrest to sentencing or to enforce consequences, but that's what we're going to dig into today. So a little bit of review before we start from Unit 6 on the left-hand side, and these things go in the margin on your note sheet. On the left-hand side will be the plaintiff versus defendant in a civil case. On the right-hand side is going to be a criminal case. So the plaintiff is the person who is making the complaint. If we were to think of these two sides as teams, the plaintiff would be offense and the defendant would be defense. Okay, so the defendant is the person who is accused of the crime, and the defense attorney is the one who represents them. The prosecuting attorney, or the plaintiff's attorney, is the one who is making the complaint. So the prosecutor here represents the government or represents the people. So if you've heard the term like the people versus Casey Anthony, or the people versus O.J. Simpson. The prosecutor represents the government and represents the people. So the people don't have to send their own attorney. We elect a district attorney every 4 to 8 years, depending on the district you live in, and they represent the people. And on the other side, the defense represents, obviously, the defendant. It sounds simple, except it's not really super simple. There are 8 total steps in the process. Number 1 is probable cause. So prior to someone being arrested, there has to be justification for doing so. Now, that doesn't mean that justification always exists. Sometimes probable cause can be a little bit of a gray area and be a little murky. We're not sure what's right and what's wrong. But typically speaking, probable cause means that there's a strong chance that someone has broken the law. However, you are innocent until you are proven guilty, because we have a presumption of innocence, as we discussed in our previous lesson. So if there is probable cause present, that is enough grounds, typically speaking, for someone in the law enforcement arena to go to a judge with an arrest warrant and say, I would like you to sign this. We have all this evidence and we have all this justification as to why this person should be arrested. Can you help us out and sign this? And they say yes, or they say no. And if they do say yes, the warrant is served on a suspect, and the suspect is arrested and informed of all the charges against them. So the law enforcement officer who arrests the suspect will say their Miranda rights, so the right to remain silent, anything you say can and will be used against you in a court of law. ... Have you read and understand these rights? Say yes, and then from them, they will ask you, with those rights in mind, do you wish to speak to me about the circumstances? You can say yes, if you would like to do so, because you know you have the right to an attorney. Or you can say no, that you would not like to speak to that person. If you say yes, you waive your right to an attorney, all right? And then they don't have to have one present in order to question you, but you can still call one in the room at any time. Number 3 is booking, okay? So this occurs if you are a suspect in a case, or someone is a suspect in a case. Booking occurs prior to that person being brought into police custody to question them. So the suspect is taken into custody, and now the suspect is no longer known as a suspect. You are now a defendant. So that person now has to defend themselves because charges have been formally brought against them. They have been booked. Their fingerprints have been taken. The mugshots have occurred. You get your fantastic orange jumper and your fake Keds and your nice bracelets, and off you go into cell block D to await your next step, which is the preliminary hearing. So this is about halfway, stepwise, through the criminal law process. That does not mean you are halfway through time-wise in the criminal law process. So by the time probable cause, an arrest warrant, central booking, and preliminary hearing have occurred, this can take anywhere from a day or a week to a month. So the preliminary hearing, the reason it takes so long is because the defendant is brought before a judge and has to learn about the charges against them. This is called habeas corpus, or to produce the body in Latin. Okay, and then the judge is going to set a bail requirement based on the case and the defendant. So the circumstances and the severity of the crime itself will dictate what the bail will be. And there is an amendment that discusses no cruel or unusual punishment, and also establishes that there shall be no excessive bails or fines. And I hope you know which one this is, because there's a question coming up. All right, it is the Eighth Amendment, if you got that right. Pat yourself on the back. All right, and a side note here, bail is money that is put up to ensure the defendant returns to court. It has absolutely nothing to do with a verdict, nothing. It doesn't matter if you're guilty or you're not guilty. Your bail money, if you come back into that courtroom, is your bail money again. Now, if that person has a failure to appear or FTA charge on their record because they did not go back to court, they have done what's called forfeiting that bail money. So they have just now, because they decided they were too cool to come to court, have allowed the prison system to take that bail money, and now somebody in cell block D gets Snickers on someone else's dime. Okay, so bail is money that ensures that they come back to court. So let's back it up here again. Moved a little too soon. All right, so let's say that we're talking about this individual here in the picture, and they are being booked on, I don't know, let's say assault and battery. No, let's not do that. Let's say breaking and entering and assault with a deadly weapon. Right? Those are, depending on the severity, those breaking and entering, if it's the first time they've done it, is typically a misdemeanor, but assault with a deadly weapon is typically a felony. Okay? So if that person has a felony, first and foremost, they're going to superior court once they go to actual court for this. And also, their bail might be like, let's say, $25,000. If that person has 25 grand, either they can put that on a check, or they can have it in cash, or they can get it from a bail bondsman. If they can post that much money, they can leave and go out and about in the community, typically only within the bounds of the county, from the time that their preliminary hearing stops until their actual next court date occurs. All right, so it has nothing to do with guilty or innocent. If the person can post bail, they can get on out. Okay? And we're moving on to our fifth one, is an indictment done by a grand jury. So now at this point, evidence is being collected in the meantime by pertinent and affected law enforcement agencies. So a grand jury is the next step. They decide if there's enough evidence to take the defendant to trial. This is not the jury that you're thinking of that sits in the corner of the courtroom like on Law and Order and says, guilty, Your Honor, or not guilty, Your Honor. That's not these people, okay? A grand jury is not quite as glamorous and not quite as dramatic as a petite jury, the one that you're thinking of in your head. A grand jury is anywhere from 20 to 25 people, okay, and they rule if there is enough evidence to take the defendant to trial or not. So what happens is the prosecution team, the one that is representing the people and is trying to put someone in prison or punish them for their crime, they present all the evidence they have gathered and all the witnesses they have collected. They bring them in front of these 20 to 25 people, and they say, here's all the evidence that we have. Is this enough to take this person to trial? That jury is not worried about whether or not someone is guilty or not guilty. That jury, the grand jury, is worried about if there is enough evidence to even go to trial in the first place. All right, and if they say yes, there is, they move to indict someone. So to indict is a verb. All right, so an indictment here. Please notice that the C is silent. Don't say that. It is indictment. Moving right along. And number 6 is an arraignment hearing. So this is the point where they say, I'm not guilty, Your Honor, or whatever that may be. The defendant is then again informed of the charges against them, if there is enough evidence to take them to trial. And then this is the point where the judge looks to them and says, how do you plead? And they'll say, guilty, Your Honor, or not guilty, Your Honor, whatever they say. If they say, I would like to plead not guilty, you move right along to the trial phase. If they do say guilty, oh, here's OJ, not feeling it, not amused. All right, if they do say guilty, we already know that. Let's inform the person in the charges. So this, another side note, probably goes in another little like call out, like pow, bang, whatever box. It says a plea deal. So if you want to plead guilty to a lesser crime, you're going to get a lesser punishment. And you have saved the court probably months of time from listening to all the stories. So if the person knows, let's say we're talking about that guy in the picture from earlier, let's say that he's got his little assault with a deadly weapon charge, let's say, which is a felony. It's a class C violent felony in North Carolina, I think. You'll have to double check me on that. But if that person says, I'll plead guilty, but I'm not pleading guilty to assault with a deadly weapon, I'll plead guilty to breaking and entering, and I'll plead guilty to possession of a firearm. Now, if they say yes, that person is going to serve significantly less jail time because he or she has saved the court so much time and has also saved themselves a whole lot of lawyer fees. So that is the smartest decision that that person could have made. So that if they cut a plea deal with the district attorney, otherwise known as the DA. Okay, then that'll help everybody out in terms of time. All right, now number 7 is the trial process. You have to, when you pick a jury to go to trial, that is a long process. You start with anywhere from 200 to 300 people in what's called the jury pool, and depending on whether or not the people in the jury pool know the defendant or know anyone who's involved in the case, they eliminate people who know anybody else, because you can't like be on a jury for your cousin. That's not how it works. You can't have a conflict of interest like that. If the person who is on trial is your neighbor, you can't be in the jury pool. So you have to make sure that we pick 12 people who are diverse gender-wise, race-wise, and socioeconomic-wise. You can't have a jury full of white people. You can't have a jury full of black men. You can't have a jury full of women. You can't have one full of just rich people or just poor people. Our jury has to be unbiased, has to be impartial. Okay, so the trial has a whole bunch of parts. You kind of bring out like your opening statement and say why we're here today, present your case, bring out your evidence, bring out your witnesses, get all the dramatic good stuff out of the way, close up your argument, and then the jury is going to reach a verdict. I know that this process looks like it's super simple. It is not. It could take months. It could take years to get all the way through this process in this middle bullet here. And then the petite jury, the one that you typically think of, is the one that reaches, oh man, that is misspelled, daggone it. All right, reaches a verdict and is typically 12 people. Now, all 12 people have to be unanimous. They all have to have the same idea, either guilty or not guilty, in order to lay down a guilty verdict. All 12 have to agree. I'll put that in the side notes. You guys can watch that video later. All right, and then number 8, this last step in the process is sentencing, okay? This is done after the defendant is found guilty. If you are not guilty and you are acquitted, like OJ, and you can go home, you don't need a sentence, and that stops at number 7 for you. Okay, but if the defendant is found guilty, they have to be sentenced. So this is based on what's called the Penal Code. It's basically a list of a giant set of here are all the crimes and here are all the punishments that match the crimes. Okay, so all of that. Sometimes the judge has a little wiggle room and sometimes the judge does not. So speaking of 2 kinds of sentencing, if the judge has wiggle room, so like 25 to life, if you've heard that for murder or whatever, or like 8 to 10 or 5 to 10 years, that is an indeterminate sentence. So it has a maximum and a minimum. The jury will decide guilty or not guilty, and the judge will decide what is appropriate based on the circumstances. And mandatory sentencing is a set punishment. So like an example of this would be armed carjacking is a 10-year minimum sentence, no matter what time it is of a crime for you. If it's your first, second, third felony, it doesn't matter. If it's the first time you have ever had anything besides a parking ticket, that doesn't matter either. Armed carjacking is 10 years, mandatory sentencing. All right, indeterminate is a little more controversial sometimes because of judges being able to say, oh, well, I'm going to only give this person 6 months. And then maybe they'll get out a little early on what's called good behavior if they don't act foolish in the pen or whatever it might be. All right, and then the very last side note, I promise. Parole versus probation are 2 different things. Parole is when you have served out your sentence, and the rest of your sentence, because you didn't act foolish while you were inside, you get to serve out the rest of your sentence in the community with your little ankle bracelet on. Okay, probation is the prisoner is supervised in the community instead of going to jail. Probation happens aside from prison. So probation is a punishment by itself. Parole is like the very end of a punishment. All right, and then loss of life real fast. First, second, and third degree murder, and then manslaughter are all different. So manslaughter sounds worse. It is not. Okay, first degree murder is premeditated, is planned. You did this, you knew you were going to do this. Second degree murder is you meant to kill someone, but it wasn't really planned. All right, so once it happened, it was planned. Third degree murder is you meant to harm somebody, you meant to go like beat the crap out of someone, and death resulted. And manslaughter is accidental death. All right. And that has been the criminal law process.